My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar Association. And want to thank you all for coming to our program. I'm taking just a minute to let all the people joining us populate into the webinar. And we'll get started very shortly because we do have a lot of material to cover today. You will find a link to the program materials in the chat. If you haven't seen those already, you can get the latest version of the program materials through the link that's in your chat. I want to let everybody know about some of our upcoming programs. We have a program on real property tax law that we're going to do probably in November. We're looking at a 1031 exchange program, which it looks like it's going to be in December. In January, we have former president of the state bar who's going to talk on some ethics issues related to risk management for lawyers, a real important subject for everybody. In February and March, we generally do a program that reviews the new law and new cases from the prior year. And also, I generally invite someone from the California Association of Realtors to come and talk about this year's changes in their forms or any new forms that they have and other issues that are sort of the hot issues for the California Association of Realtors on residential real estate. We also are planning a program next year on the changes that have taken place in foreclosure law. I want to remind everybody that you put your questions, please, in the Q&A, and we'll be monitoring those and try to respond to all of them at an appropriate time during the program. And finally, your MCLE credit certificates will go out promptly after the program. The Beverly Hills Bar tends to be very good about getting those out quickly. So it's my pleasure to invite our speakers who are actually lawyers not in California. They're both with the Arendt Fox Schiff law firm. First, I'm going to introduce Lindsay Karotkin. Lindsay is a partner in the New York office of Arendt Fox Schiff, which is an AmLaw 100 US law firm with approximately 650 attorneys, whose intellectual property group is highly ranked and recognized by Chambers, the Legal 500, and the World Trademark Review. Lindsay is on brand protection and intellectual property counseling and litigation for clients ranging from Fortune 10 companies to individuals and family businesses across a wide array of industries, including architecture, interior design, and real estate. On the litigation side of her practice, Lindsay represents clients in connection with IP infringement, defamation, breach of contract, and other related claims in both federal and state courts. She also helps clients obtain trademark copy registrations around the world and negotiates contracts, including the IP terms in complex real estate and design-related agreements. Also with us is Sarah Alberstein from the DC office of Arendt Fox, where she is an associate. Sarah advises fashion, arts, and entertainment, tech, and retail clients on global and domestic intellectual property prosecution, enforcement, counseling, transactions, and litigation. And she also conducts due diligence for real estate and merger and acquisition transactions. So here we go with the intersection of intellectual property law and real estate. Thank you both for joining us.
Thanks, Howard.
Thank you. Thanks, Howard. Thanks, everyone, for being here. So we are here. We can go to the next slide. We are here today to talk about the intersection of IP and real estate. One of the things we're really going to focus on is the tension between the rights of IP owners and the rights of real property owners. As we'll see in the cases we discuss, sometimes the IP owners win, sometimes the real property owners win, and it's fascinating to see how and why that happens. The goal for us really in this CLE is to arm you guys as the listeners with the tools to identify where IP rights may exist in the world of real estate and architecture. We're going to go through cases, identify some of the hot button risks and issues in this space, and then do our best to give you the tools to try to attack those risks head on and mitigate them where possible, including as early as the contract negotiation stage. We'll start with the world of copyright. Then we'll talk about how trademark and trade dress rights come into play in the world of real estate. We'll then go into VARA and the issue of moral rights, and we'll wrap things up by talking about some unique cases of landlord liability for IP infringement of its tenants, and we'll end with some trends in listing photography litigation. We can go to the next slide, which will lead us to the world of copyright. And in this section, we'll be looking at how copyright can be used to protect buildings, designs, and plans. We can go to the next slide. So level setting, what is copyright? Copyright is a type of intangible property, IP right. It generally protects original works of authorship, fixed and intangible means of expression. Things that might come to mind are paintings and novels, but there are ways that copyright law can be used to protect assets within the world of real estate and architecture. First, we have the easy case. Architects, designers can protect plans, drawings, schematics as two-dimensional works. You can also protect models as sculptural works. If you own a copyright for any of these works, this gives the IP owner the exclusive right to make and distribute copies, to publicly display the work, and to make derivatives, which is really a fancy way for saying a version based off of the original version. The other thing that the copyright gives the owner the right to do is to sue for infringement. What is infringing is a complex question, but for our purposes, we can just say you can sue for infringement if someone uses the same work or something that's substantially similar to your work. Going to the next slide, the more complicated and more nuanced and narrower way that we can have copyright protection in the world of architecture. It's really new since 1990. The US Copyright Act was amended to provide some copyright protection for buildings themselves as architectural works. In order to meet this qualification, the building has to be habitable by a person, intended to be permanent and stationary. What does that mean? It means bridges, dams, walkways, and RVs cannot get copyright protection as architectural works, but houses and skyscrapers potentially can. In order to meet this qualification, the work has to be original. And even if you get the rights, you can't use copyright in an architectural work to claim protection over standard features like the fact that the building has a door or a window. Copyright's really trying to protect unique expression and not just ideas or general concepts. There are two important exceptions we'll see in the cases for architectural works. First, you can't use an architectural work copyright registration to prevent someone from an artistic reproduction of that architectural work if the building is visible in a public place. The second caveat that comes into play more is that you cannot use an architectural work copyright registration to restrict a building owner from altering the building without consent. And we'll see how that comes up in the cases in a minute. But going to the next slide, before we get into those cases, we wanted to quickly give you guys a level setting landscape of what are the key questions that come up in a copyright infringement or litigation action. Number one, key question, is the asserted work original to warrant protection? Number two, was there actionable copying? Number three, this is the heart of these cases, is there substantial similarity between the protectable elements of the works, right? So we're not just looking at, do the works both have doors, but do they both have the same unique elements of the door that are protectable? Is there some sort of interesting engraving or something interesting about the ratio that would make that door protectable beyond the idea of a door? And then lastly, are there contractual provisions or defenses that come into play, which often tends to be the case. Going to the next slide, the first case that we're going to look at is the Freedom Tower case. This is a case that came up between a student who claimed that his model was infringed by an architect who worked with Skidmore and Owens, who was also a juror for this student's design competition when they were at Yale University. The outcome of this case is that the student won in part. The court found that there were triable issues about whether or not there was substantial similarity, right, actionable similarity to support a copyright infringement claim between the student's model and the architect's design for the Freedom Tower. It was a long drawn out case. The case ended up settling before trial in 2006. We don't know the terms of the settlement, but we can assume that the student probably got something, considering that the court found there was a reason to at least have a trial. Going to the next case, we have Cornice and Rose versus Four Keys. This is a pretty straightforward case that shows us the power of that Section 120 exception to architectural work protection we just talked about. In this case, a bank purchased an incomplete building through bankruptcy. They decide to complete the building without permission from the original architectural firm, and they also didn't involve that firm. We don't know the exact facts of what happened, but we do know that the architect still owned the copyright in the building as an architectural work. So the architect had some leverage, tried to sue for copyright infringement, and basically said, by you, new owner, completing the building without me and without my consent, you have violated my copyright and my architectural work. You've created a derivative. This is infringement. The court pretty swiftly dismissed that claim and said, under Section 120, this claim can't survive. The building owner is allowed to alter the building, even if the architectural work is protected, and even if the building owner doesn't own that copyright. This decision was affirmed by the Eighth Circuit, although on procedural grounds that weren't related to that issue there. That takes us to contractual considerations, which is the next slide. So here we just wanted to quickly sum up for you guys. If you're dealing with agreements involving IP creators and building owners, you want to keep a few things in mind. First, you want to make sure you confirm and specify ownership. That includes ownership of plans, models, buildings, and derivatives. Ownership is always the best. You're going to be in the strongest position if you own the rights. There can only be one owner. So if you're representing a client or your own interest and you can't have ownership over the IP, the next thing you want to be looking for is a robust licensing right. License is second best, ownership is best. When you're in the world of a license, the broader, the better. And you want to make sure that the licenses, if you want to have the rights to do new things, include the right to make derivative works, which has to be expressly called out. And with that, we're going to move over to Sarah and talk a little bit about how trademark and trade dress comes into play for protecting buildings.
Thanks, Lindsay. As Lindsay just mentioned, we're going to pivot over to trade dress. This is not mutually exclusive with copyrights, and we often advise clients to consider protecting both their copyrights and their trade dress as a sort of more robust protection and enforcement strategy. Moving to the next slide. So what exactly is trade dress? It protects the overall look and feel of a product or its packaging. We often see this. Here's some examples on the side, with consumer products like bottles of soda, shoes, things like that. In the real estate context, what we're talking about is the visual appearance of the buildings and structures, the interior store layouts, and the facades of the buildings. And as we'll get into later, we'll provide some examples of each of these. Importantly, to actually secure trade dress registration, the trade dress must be distinctive, either inherently or through secondary meaning or acquired distinctiveness, which we'll go through later on in the presentation. The trade dress must also be non-functional, which can sometimes be a tough barrier to clear in the world of architecture and real estate, but as we'll see later on, it is possible. And lastly, it must be source identifying. And what we mean by that is that a consumer encountering the trade dress in the world should be able to see it and know by looking at it who the source of the underlying goods and services actually is. Importantly, trade dress can be registered or unregistered. Unregistered trade dress rights are enforceable. However, we generally recommend to secure registrations wherever possible because they provide prima facie evidence that indeed this trade dress is distinctive, non-functional, and source identifying. And that can be a really helpful sort of tool when you're enforcing those rights out the gate. So moving
Where are you registering the trade dress?
So you register the trade dress with the United States Patent and Trademark Office, and that secures you national trademark rights in that trade dress, such that you can enforce it in any number of states.
So it's basically registered as a trademark?
Yeah. Trade dress is basically a sort of subsumed within trademark law. The same acts apply to trade dress. They're just slightly different rules and levers that you would use for trade dress versus a word mark, for example. Okay, so moving on to the next slide. Before we get into this case, I also just want to briefly touch on a little bit what distinctiveness means in the world of trademark. It's very complicated, so I'll try and keep it relatively high level. Distinctiveness is basically a spectrum of protectability for a mark or trade dress. Essentially, the more distinctive or unique trademark or trade dress is, the more likely to be protected. So what you really want is something to be on the upper end of distinctiveness, and the more generic or basic something might be, the less likely it is to be eligible for protection in the first place. And even if you can, even if it is eligible, the more barriers you'll have to registration or enforcement of those rights. So now digging into this case, Two Paces versus Taco Cabana, this is actually a seminal trade dress case in general. And for our purposes, we're lucky because it's also a real estate case. This is a Supreme Court case from 1992. It was a dispute between two Mexican restaurants. They both featured, very colorful palettes, a highly distinctive, patio. The interior store layouts were the same. And basically the senior restaurant sued the junior restaurant for infringement of their trade dress. And this case is so important because for the first time, the Supreme Court held that trade dress can be inherently distinctive. And in fact, a restaurant, a physical building's trade dress can be inherently distinctive. And so in this case, the Supreme Court ruled that there was in fact infringement of the trade dress without a showing of secondary meaning. So this has had significant ramifications in the trade dress world in general, and is, like I said, a landmark ruling.
How would you measure damages, or would it simply be an injunctive case?
So in trademark cases, you can pursue both injunctive relief and damages. There are statutory damages, and there are also actual damages available. A lot of times the calculus is based on the sort of financial loss to the business based on the junior user's abuse of the goodwill in that mark. It can sometimes be really difficult to track down, unlike in copyright law, for example, where there's a really clear statutory range. But in answer to your question, both injunctive relief and damages are available.
Thank you.
So pivoting to the next slide, we wanted to show you some examples of what it actually, some actually federally registered trade dress. We're going to show you examples of trade dress in the buildings themselves, facades of buildings, and in interior store layouts. So here we have two really good examples. We have the Perot Museum of Science in Dallas, Texas, and we have the Wynn Casino on the Vegas Strip. Both of these registrants were able to secure registration in their trade dress for the buildings. As you can see, these are both really unique building designs. That's kind of exactly what we're looking for with trade dress. Someone walking down the street sees this and they know exactly who is behind these buildings. One thing to also note, so these illustrations on the top are what you would actually submit to the U.S. Patent and Trademark Office to, detail what your trade dress actually is. Versus, of course, we have the actual physical structures below. One thing also to note in the illustrations, the dashed lines are expressly excluded from the scope of protection for that trade dress. What you're looking at is the solid lines. That's what's being protected here. So moving on to the next slide, I always like to include the Infinity dealerships. Because I think that this is a really excellent example of how trade dress can be used by businesses. So basically, if you go to any Infinity dealership across the country, you're going to see this facade. So not only are you sort of strengthening your IP here, you're anywhere you go, you're seeing the same thing. The more consumers kind of encounter this, the more source identifying and more sort of vigorous your protection is. This is exactly kind of what we're looking for. And I think it can be really useful, especially for businesses that use a franchise model. You want to be repeating the trade dress over and over again and creating this association in consumers' minds that this facade is our business. Every time you see this, it's us, infinity. I think, I often think about like the Pizza Hut example, where when you go to any Pizza Hut for a while, I don't think they're like this anymore now that they're more modernized, but for a while you would see like this hut and you knew immediately that was Pizza Hut. Another example here is the Medina Country Club. Here they were able to secure trade dress registration for their distinctive design. That's just another example of a facade that was capable of trade dress registration. Going to the next slide, we'll actually see how you can secure registration not only for the exterior of your building, but also the interior store layout. I think the Apple Store example is a really good illustration of this. You can close your eyes and imagine the layout of an Apple Store. That's kind of the source identifying function of trade dress, even without the name Apple, on the facade here or on the, on the walls of the store. We know that that's an Apple store. It's distinctive, it's unique. You're only going to see this in an Apple Store. We know that you're going to be able to buy Apple products when you come across a store that looks like this. That's sort of the real function of trade dress, and is why it's kind of an important complement to copyright. It kind of protects this source identifying feature of the store. The Gibson store is another good example of this, and I think is a really good example of what, these dashed lines being really particular about what you're claiming protection in. Here, I'm sure that Gibson owns word mark registrations and their stylized Gibson marks, but they've excluded it here. They're really focusing on the store layout as what they're seeking protection in this case. So pivoting to the next slide to actually see some applications of these concepts, we have In Re Palacio del Rio. This is a case where a party was not successful in securing trade dress registration. The examiner refused registration because they felt that this building, which is, a wall of windows and pretty basic structures, was not sufficiently distinctive to warrant trade dress protection. The application argued that, well, to the extent that these individual features are not protectable, the amalgamation of them creates a distinctive trade dress, and we should be able to secure registration in it. The Trademark Trial and Appeal Board disagreed, and In Re Palacio was ultimately not able to secure the registration. The application went abandoned. If we go to the next slide, we can see a really strong sort of comparison, right? We have In Re Seminole Tribe of Florida. Here, the building is the shape of a guitar. That is just extremely unique, highly distinctive, exactly the kind of thing you would expect to be able to secure trade dress in. Even though in this case, the examiner initially refused registration, the applicant appealed to the Trademark Trial and Appeal Board. The board agreed with the applicant and said, no, this is exactly what we're looking for. This is highly distinctive. In fact, there are no other buildings in the country that look like this. The applicant should be able to secure registration, and indeed they did so. One thing I'll also note here is that in this case, the board cited to this prior holding in Re Furniture Mart Holdings 1 LLC, which was a case that held that a building's facade can function as a trademark. So we have this kind of growing body of TTAB precedents that helps us secure trade dress protection for these very, very unique buildings. Pivoting to the last slide in this section, we have another application of trade dress with respect to the interior of stores. Here we have Best Sellers, which is a wine retailer that created this really unique layout. You can see a picture of it here. Grapevines, which had a wine store in Washington, D.C. Their principals actually visited the Best Sellers stores, were very entranced by it, as I'm sure we all are looking at this image, and decided that they would go ahead and replicate it. That was not taken well by Best Sellers, who sued for trade dress infringement and were successful in securing a preliminary injunction from the court, who found that Best Sellers' trade dress in their interior store layouts and design was inherently distinctive and non-functional. So they were successful in stopping Grapevines from proceeding in this case. So that takes us to the next
A
section.
couple real quick questions, Sarah, about that.
Sure.
Do the interior designers, decorators, architects seek trademark protection, or is it usually the owner of the store?
It's usually the owner of the store, because again, what we're talking about with trade dress and trademark is the source of the underlying goods and services. So in this case, right, it's not the architect or the designer who created this that's offering these this wine. It's the business, Bestsellers Inc. Of course, you want to have really robust agreements in place with any third parties that you're involving in the design process to ensure that any rights they may have or claim to have are sort of very expressly assigned to the business at the end of the day. But typically what we see is the businesses applying for
And I
registry.
suppose like
Yeah, and Howard, I would just jump in. We do also represent a lot of interior designers who are expressly hired for the look and feel of their style, and negotiating those types of agreements can get more complicated because the store wants to own the rights to the look and feel of the store, but they also want the look and feel of the interior designer, which they need to protect in order to be hired again. So it can get very tricky.
Very interesting. And I suppose, as in most trademark cases, if you have a registration, it's going to be much easier in the litigation than if it's an unregistered trade dress.
Yes,
Yes.
that's absolutely the case.
Okay, so this takes us to the world of VARA, Visual Artist Rights Act. In the US, through the Copyright Act, we have some limited protection for artist rights, also sometimes referred to as moral rights. We can go to the next slide. This tends to be it's a great area of law for the artists, but can be very, very scary for building owners. A lot of them don't know about it, and they do need to know about it to avoid getting into trouble. So generally speaking, the Copyright Act provides some limited protection for these rights. What is protected? Paintings, drawings, sculptures, prints, certain types of photographs as well. It does not protect things like maps or technical drawings or works that are made for hire. There are a few different rights that are protected. The first right is pretty easy, the right of attribution. The author has the right to claim authorship and to prevent from false attribution. So if you have a KAWS sculpture in your lobby, you have to say KAWS made it. And if you have a knockoff, you can't say that KAWS made the knockoff, or you could get into trouble. Where things get more interesting and a little more complicated involves the right of integrity. Through US law, artists are given the right to object to the intentional distortion, mutilation, or modification of their work if it's prejudicial to their reputation. Very difficult to prove exactly what this is, involves a lot of litigation, but some easy examples. If you have a mural on the wall of your building and the paint chips, you can repair it faithfully to the color that was chipped off, probably without violating the right of integrity. But if you completely change the color, you could get into an issue where the artist claims that your modification of the work was prejudicial to their reputation. Within the universe of the right of integrity, there is also a limited right to prevent the destruction, the intentional or grossly negligent destruction of works protected under VARA. But this is a little more narrow, and it's limited to works of recognized stature, which usually means the artist is famous or well-known, or, the community has some appreciation for the work. If a toddler does a painting on a wall and the wall gets destroyed, it's probably not a VARA violation. But if a famous museum exhibiting artist has their mural destroyed, it probably is a violation of this provision under VARA. We can go to the next. Yes.
What happens if you have a building beyond its useful life, or for economic reasons, you need to touch that artwork and change the building?
You may have an issue, and we'll go to the next slide and start to talk about some of the caveats. But you may have an issue, and there are times where moral rights will see trump the rights of real estate property owners. So we have some caveats. There are legislative ones as well as contractual. First, under US law, VARA doesn't apply to works that are installed in buildings on consent before the effective date in 1991. It also doesn't apply to works made for hire. So that's another safety valve. And then contractually, we'll get to it more on the next slide, but VARA rights can be waived away in an agreement. Going to the next slide, which I think touches on some of what Howard was addressing, when it comes to the question of whether a work is destroyed or distorted, mutilated, or modified in some way, there are a few different safety valves that are in the statute. So first, if you're dealing with non-removable work, there is no VARA liability if the work is destroyed, distorted, or mutilated, if either the artist consented to the installation, and that all happened before 1991, right? So older works before VARA, you're not, if you destroy the whole building and the sculpture gets destroyed, you're not going to have a claim on your hands because you had it installed before this law even existed. And then the second way you can be protected is if you have a waiver. So you're dealing with works installed after 1991, and the artist has to consent in a document that the removal of their work after installation could result in destruction, distortion, mutilation, or modification. It's where contracts come in and are so important. Artists, for various reasons, might not always agree to that term, which we'll talk about in a little bit, but waiver is the safest way to be protected as a building owner. The other caveat that's in the statute, if you're dealing with removable works, if the work can be removed without destroying, distorting, mutilating, or modifying, which tends to be the vast majority of these works, there will be no VARA liability even if you destroy the work, assuming that you either make a diligent, good faith attempt without success to notify the artist, the creator of your intended action, or you give them actual notice and 90 days, and within those 90 days, the artist does not remove or pay for the removal of the work. Then you can go ahead and knock down the building without there being a VARA violation. Where this leaves us, one of the biggest risks is you have a work that's installed after 1991. There's no contractual VARA waiver, and the work cannot be removed without destroying it, distorting it, mutilating it, or modifying it. In this case, you're in a very difficult situation. What you need to do is call your lawyer. Do not bulldoze your way through it, no pun intended. It's a tricky situation. Usually, with money or other terms, you can negotiate your way out of this problem, but you have a problem on your hands and you should not just destroy the building. You should try to work this out a different way. There is some good news. We know that things like incidental damage due to exposure from the elements or the passage of time doesn't create VARA liability. So that's a little bit of good news for property owners. We're going to get into some cases now, but the takeaway, as we'll see, is that sometimes the real property owner loses, and it can be a real shock because a lot of property owners either don't know about VARA, or they don't really understand the implications of what they're doing, or they may even forget, that there's a site-specific artwork in the building in the first place when they decide to modify or tear down or destroy in some way. So going to the first case, this ends up being a good case for the property owner. Here, on appeal, the work was determined to be a work made for hire. Works made for hire are not protected under VARA, so the building owner won. This case was a little bit shocking, though, because basically there was a lower court decision, there was a TRO and a PI, and then a bench trial, all go in favor of the artist. The court ends up granting a permanent injunction, but no damages. But the court enjoined the building owner and said, you are prohibited from destroying, distorting, mutilating, or removing this artwork for the lifetime of the artists, right? Could be decades. You have this big installation. Some people may like it. The new building owner here didn't. The lower court said, sorry, you're stuck with it until these artists pass away. Gets appealed to the Second Circuit. The Second Circuit digs into the factual record in a different way and reaches a different conclusion based on a finding that this artist had been working for the original building owner for like 2 years, working on all different things around the building. This wasn't just a one-off commission. The relationship was more akin to an employee-employer, which made it a work made for hire, and so VARA did not apply. So here the building owner was able to escape liability after a very scary situation before the lower court. That's not always the case, as we'll see in the next case. So the next slide shows Martin versus City of Indianapolis. Here we have an instance where a VARA violation was found. In this case, an artist had created a sculpture on land owned by the artist's employer, but the record showed that the work was all done outside the scope of his employment, Most of the work was done on the weekends and the holidays and really had nothing to do with the work he was doing for the employer. In the meantime, the city of Indianapolis acquires the land and wants to sort of do a clean slate, including get rid of the sculpture, didn't give the artist the right or ability to remove the sculpture. The artist was obviously upset about this. The artist sues. The court grants summary judgment in favor of the artist, including awarding statutory damages of $20,000. And here's the kicker. The court thought that the city was really operating in bad faith. And so they also awarded attorney's fees, and that attorney's fee and damages award was affirmed on appeal. So obviously this was a big embarrassment for the city. And, you know, if they had gone to the artist first and given the artist the opportunity to maybe take the work off the property, negotiated some of those terms, they might not have had this kind of a situation on their hands. But this is really worst case scenario for property owners. We're going to now quickly shift over to some more recent cases dealing with VARA issues in the world of street art and murals. Two cases with very different outcomes, and Sarah's going to cover those.
Sure. So this first case we have is called the 5 Points case, Cohen versus G&M Realty. In this case, we had a developer that owned this series of kind of interconnected warehouses, and he decided that he wanted to turn this into kind of an outdoor exhibition space for graffiti art. He, got a bunch of different artists to come and spray paint and cover the building in their art. 10 years later, he changed his mind, which, people often do, decided he wanted to remove all this graffiti art. He planned to whitewash it. The artist caught wind of this and asserted their rights under VARA. They sued and were successful in getting a TRO against the developer to stop the removal of these works. The court ultimately was hesitant to convert that TRO into a PI, but did expressly warn the developers that, if the case is going to proceed, if the artists are successful and you take action while the case is pending, you may be liable for significant damages and in fact potentially liable for willfulness. The developer sort of ignored that warning from the court, and decided nonetheless to go ahead and whitewash all of these pieces. And that ended up being a pretty costly mistake for the business developer. The court awarded maximum damages against the developer, including for willfulness, and then that resulted in a $6.75 million price tag that the developer had to pay. So this is another case where business developer made a sort of a grave error and ended up being quite pricey. And this is just an example of, people change their mind. You want to make sure from the jump that you set yourself up so that you can change your mind 10 years later if you want to.
This sounds like a case where the owner either didn't get proper notice from his counsel about the statutory 90 days to salvage the art, or just chose to ignore it.
There's a lot in the record about him being very aggressive, and it's interesting because you would think that graffiti can't be removed from the wall of a building, but the artist had actually presented testimony in this case that they could have removed it if they were given the opportunity to.
Great.
So this next case, the Vermont Law School case, Kirsten versus Vermont Law School, is a interesting counterexample to the 5 Points case. Here again, we have a mural on the building. The school had commissioned an artist to make this mural. Over time, as sort of society kind of evolved, many people felt that this mural was actually quite offensive, and the school started to receive a lot of complaints petitioning for the removal of this mural. The school was maybe a bit more aware of VARA than the developer, and 5 Points was cautious, and rather than destroy or paint over or remove this mural, they instead decided to obstruct it from view behind some panels. The artist was still pretty upset that the mural was removed from public view and sued under VARA. However, the court held that the school did nothing wrong. They didn't destroy, mutilate. The mural was still there. It just was covered up, and that is not actionable under VARA. So this is an interesting counterpoint where, you know, there can be creative solutions under this act. So going to the next slide, we can take kind of all that we've learned from the you know, wins and losses from the last cases. And, you know, the main takeaway from all of this body of law is that you really want to set yourself up at the beginning, before any disputes arise, before, you know, emotions and tensions run high, and that can happen at the contractual level. You want to be thinking about VARA rights. We know that they can be waived. That's something to consider putting in a contract as a property owner. Oftentimes with more sophisticated artists who are aware of their rights under VARA, or, you know, who are bigger and have negotiated a lot of these contracts, they're not going to be willing to waive their rights under VARA. And so you want to be having that conversation at the beginning to think about what kinds of other safeguards you can put in place, you know, knowing that they may not be willing to waive their rights outright. So that can include considering, you know, the terms for removal or destruction. What does that actually look like when that time comes? Being explicit about, you know, notice and who bears the costs for removal. You want to pre-negotiate any permissible alterations and modifications. This includes any necessary repairs, relocation. And then finally, you know, we see how big these cases can get, how complicated litigation can be. And so we really encourage considering dispute resolution, or ADR, in the contracts out the gate. And that can really help save a lot of time and money down the road. So pivoting to the next section of the presentation, we're going to talk about landlord liability for tenants' infringements. I'm sure that, well, I'm not sure, but I would venture to guess that a lot of you probably did not even know that this was possible, but it is. So going to the next slide, we're actually seeing an increasing trend of this kind of liability in the IP space, where landlords are being held liable for the infringements and counterfeiting efforts of their tenants. This arises when the landlord has actual knowledge, should have known, or turns a blind eye to counterfeiting efforts that are happening within their buildings. The most important takeaway from these cases is that you really can't ignore it. You can't bury your head in the sand. Once you become aware that there's counterfeiting, there's trademark infringement happening on your premises, you need to start taking action, and you need to start documenting that action. So going to the next slide, we have a recent example of this in the Luxottica Group case. So here there was a mall where retailers within that mall, tenants within that mall, were selling counterfeit sunglasses. The manufacturers of those sunglasses were, you know, they were sending demand letters to the mall. They were putting the mall on notice, and the mall just kept ignoring it. There were, you know, ultimately there were multiple raids at the mall. The project manager at the mall was served warrants with lists of the brands and products that were being counterfeited at that mall. There were trailers in front of the mall where they were loading up all the seized goods. And so there just was no way really for the mall to say, we had no idea, you know, mea culpa. And ultimately, the manufacturer sued the mall for the infringements of the mall's tenants, and they were successful. And they secured a $1.9 million damages award that was affirmed on appeal. In this case, the defendants certainly knew, or at least should have known. And so, like I said, we're seeing an increasing trend, often in the sort of counterfeiting space. And so it's just something to be aware of. Going to the next slide. Again, this is another space where we can preempt a lot of these really negative outcomes at the contract stage. Knowing that as a building owner, you can be held liable for the infringements of your tenants, you want to bake that into your contract. You want to have express provisions prohibiting that kind of activity, prohibiting IP infringement and counterfeiting. And you also want to be clear about that being a basis for termination. And you want that to be really expressed. You know, if we see this type of activity, that's grounds for termination. And then finally, as I mentioned before, if you're starting to notice this happening, if you're starting to feel suspicious, or if you become actually aware, you need to start taking action, and you need to start documenting that. That way, if and when a case is levied, you can say, Sure, but I terminated the lease. Like, I'm not held liable. I took action as soon as I became aware of this. And then we'll end on another sort of quick thing to.
One more point on that, Sarah. I suppose you also could think about an indemnity provision if the tenant has assets or something.
Yeah,
Yeah.
it's a good point. Okay, so this is the last section, which is just a quick note about listing photography in real estate listings. Going to the next slide. This is another space where we're seeing an increasing number of cases being filed against, places like Zillow or other kind of real estate listing networks. What's important to note here is that photographs are subject to copyright protection, and each individual photograph is protectable as an independent work. So just because you're coming across a picture of a house online, you can't just copy, paste, and upload that to your real estate listing. You need proper permission, a license, ownership, something like this. You can take your own pictures in-house, but you can't just copy and paste existing photographs and upload it. So we can go to the next slide, and I'll circle back to AI at the end. This is an example of one of these cases. Here, Zillow had copied over 2,000 photographs belonging to VHT and uploaded it to their sites. VHT sued. Zillow tried to argue that, well, we're cropping the photographs, we're changing things a little bit, therefore it's transformative use, it's defensible, it's fair use. The court did not agree with that. They said, no, this is not fair use, this is copyright infringement, and issued a $1.9 million damages award for VHT. And part of the reason that damages award is so high is because, as I mentioned, each individual photograph is subject to damages. So for each one, you're looking at damages of between $750 to $30,000 per photograph. And then that can go up to $150,000 for willfulness. So, with sites like this, it's so easy. I mean, they copied over $2,000 photographs just here. So each listing can have, 12 photographs. Each one of those 12 photographs is subject to damages. So that's just something to keep in mind.
How would the damages go up from the 750 to the maximum there? What do they look at?
The range, the $750 to $30,000 range is at the discretion of the court. There are different fact patterns that result in different damages within that range. We're talking about the amount that's been copied. We're talking about if there's any relationship between the parties. But ultimately it's really at the discretion of the court.
So if you're the counsel there, what sort of factors are you going to argue to the court to get it from the lower range to the higher range?
So
Yeah.
Oh, sorry, Lindsay, go ahead.
I was just going to say that the one of the key things will also be the market value for the photograph at issue. So you'll often look at the licensing rates for that work or for similar works, but you can get multipliers if a party is found to have been copying or infringing willfully, which can include willful blindness. And so that's where you're starting to look at multipliers off of what a market rate is.
Mm-hmm.
Thank you.
Okay. Well, that actually closes out our presentation. We, I think, have a few, maybe 10 minutes for questions. Is that right, Howard?
Yeah, when we want to go up ahead and use the full 10 minutes, but I don't have questions from the people in attendance, but I had a couple other things to ask you myself. One of the things that I've talked to people about, I mentioned this program and things like this, that you see lawyers and other people do quite a lot, is they'll take a picture of the office building they're in and put it on their website or their business cards or things like that. My understanding is that is problematic for the person doing it.
Yeah, it depends on what the building is, but the nice thing is when you're doing things for personal use, there's often fair use exceptions. So there are things that you see you could see on, you know, someone's individual card or even posts you see on social media that either someone would never get sued over, or there might be a fair use defense where if Coca-Cola did the exact same thing, they'd be considered to be doing it for a commercial purpose, and they would probably be liable.
Yeah, in addition to that, it's also permissible to take your own photograph of a building that's publicly viewable from, you know, from the sidewalk. There's a pretty robust body of law around that.
So that would suggest that I could put it on my website and it wouldn't be a problem. What if
It
it's,
wouldn't
what if it's a registered design?
Yeah, even then, I mean, you know, for example, we've had clients where, you know, they have, you know, did a fashion shoot in front of, you know, on the streets of New York. There are buildings in the background. There's no infringement of the copyright in the architectural work there.
So
Yeah,
somebody,
but where things can get a little tricky, going back to the Vara cases, is if that building has graffiti on it. We've seen a
Yeah.
lot of cases where the artists then sue. So even if the building owner can't sue because they have a copyright in the building as an architectural work, that same kind of exemption doesn't apply for art that is on the building. So you have cases, and there have been a few notable examples recently where graffiti artists say, your commercial infringed my copyright in my graffiti. You didn't get my permission to include it, and so I can sue you for copyright infringement. So it's not just the building, but what's on the building where you can sometimes get into
so
trouble.
does a building owner have a problem if somebody puts graffiti up and they don't take it down right away? I assume that they have a right immediately to take it down or do something else, but if they leave it up for a long time, are they then perhaps subjecting themselves to liability when they do remove it?
It's tricky, and there are like two Vara cases on this issue, and so, you know, they've acknowledged it's a gray area of law because the statute doesn't expressly say that Vara is limited to works that were applied somewhere with consent. But the two courts that have looked into this issue have basically read in that as a requirement, that in order to have Vara protection, the work has to be put up legally. And in the case of 5 Points, the works were put up legally, and there was a curator involved. So even though it, you know, it looked like graffiti, and a lot of the artists who did the work have works around the world that they didn't do legally, in that case, they were legally applied. But there have been two cases that looked at the issue and said, you know, it would be a perverse incentive if we were to permit this kind of protection for someone who doesn't have the legal right to put graffiti or you know, art on a building, because then the building owner, just by cleaning up the mess, would be subject to liability under the Copyright Act, and that just doesn't seem to be the purpose and intent of the statute. But
We
it's
do
a
have-
hard question.
We do now have 4 questions that just came up. Someone
Okay.
wanted to know if there's VARA protection for artists like Banksy.
Yeah.
And somebody else asked, when does posting a photo of a building or mural in a social media post turn from fair use into infringement? Or does it?
Yeah, I mean, it can. It's more likely going to be the case if it's done by a commercial player and they're doing it in a way, if it's trademark, that it's confusing as to source, or yeah, it can come up in the copyright context too. But it's an interesting point, because from our perspective, the world of social media is still a little bit like the wild, wild west. And from a lawyer's perspective, an IP lawyer's perspective, there's really two social medias. There's things that people do and things that businesses do. And sometimes things that people do, like in the case of reposting paparazzi photographs, you can get into trouble. But for the most part, a lot of what people do kind of flies under the surface or would be fair use. And if it's done by a business, the same thing could be found infringing.
What if an individual uses photos you took for their professional websites or LinkedIn.com?
Sorry, to clarify the question, is the question a third party took a photograph of you and you upload it to your website, or you took your own photo and you put it on LinkedIn?
I think somebody's asking, what if the individual took some photos and then somebody used it for their professional website or LinkedIn or .com, like something like that.
I mean, it's technically actionable even if you're the subject of the photograph. If a photographer took a picture of you, they own the copyrights in that photo, absent, you know, an agreement or some other transfer of ownership, and then you upload that. It's technically actionable. Again, as Lindsay said, there's a question about whether the display is commercial or not, what exactly you're using it for that can come into play. But at a baseline, yeah, that falls under
So
copyright.
somebody just puts an interesting photo up in social media and somebody says, gee, I like it, and they take it and use it on their website or LinkedIn or something, they could have liability to that individual who put it out publicly in social media.
Yeah, and that's why we see so many. I mean, there's a whole sort of industry of these third-party kind of, they're almost like troll adjacent copyright monitoring services that just crawl the web for this exact type of copying that a lot of people just aren't thinking might subject them to liability. And as soon as they see, you know, one of their clients' works uploaded to another website, you'll get a letter that says, you know, pay me $30,000, whatever. Like because it happens just like this. You come across something online, you copy it, you think it's innocent. It's not. It's not always innocent.
Yes, and I've worked on a lot of these with Sarah. We're seeing a lot of these even if there's a Creative Commons license involved, because under the old versions of the Creative Commons license, if you like violated a small term, like you didn't put in the right attribution, the license would basically be ineffective. And so we would have, we would get these kinds of letters, even though the photograph was under a Creative Commons license, because it wasn't technically complied with. And there are these services that just scrape the internet looking for violations.
Somebody else asked, I'm not sure if I get this completely. Is there any successful case of fair use for the property market? I'm not sure exactly in what context that would come up, but and their second question was, how is AI used so far in the property market?
Oh yeah, that's a great reminder. I said that I would circle back to AI and didn't. I was going to mention in the listing photography section that we are seeing more, you know, in general, we're seeing AI used more. We're also seeing it used to generate listing photographs. As of right now, it's an ever-changing area of law, but as of right now, there's no copyright protection for works generated by AI because it technically does not have human authorship. That may change, we don't know, but that's where it stands right now. I think there's a more complicated question when, for example, you take a photograph off the internet that someone has copyrights in, and then you use AI to, let's say, put furniture in the image. I think that becomes a much more complicated question. I think one side might say, well, I have rights in that work. You've created a derivative of it. You're, you know, infringing my rights, and I have a claim. I think the other side would say, well, you know, AI is a wild west. I'm not doing anything that I'm not supposed to. AI just did this. It wasn't me. So I think it's a complicated area of law. I personally think in general, just don't use anybody else's pictures, whether you're attaching AI to it or not. I think in that case, even if you're putting, you know, pictures of chairs in the room, they still have rights in that image and you're copying that image.
So if you have a defense that something was created by AI, how do you go in and find out if that particular work or that photograph was created by AI or not?
I mean, there are a lot of, oh, sorry.
Go ahead, Sarah.
I was going to say, this is not necessarily a legal answer, but there are a lot of kind of telltale signs of AI use. And we see this sometimes in the copyright space where, you know, there's someone took a photograph of, you know, soccer players on the field and they have, you know, trademarks on their jerseys. And then you ask ChatGPT to create an image of two people playing soccer and you get this image back that kind of looks like it, but it's like everything's kind of distorted. People have like 4 different, you know, people have 8 fingers, whatever. They're these kind of telltale signs of AI use. So that's how I've seen it. I don't know, Lindsay, if you're aware of other ways?
Yeah, I mean, there are discovery devices you can use. First, it's becoming kind of standard practice for companies that are using some AI in their creative process to have their designers or creators have creation logs where they're documenting when the AI input was included. Because the way copyright law works right now, you're going to need to tell the Copyright Office or tell a court what parts of the creation was made by a human and what parts was made by AI. So there's probably discoverable documents out there to show what, if you're dealing with a professional business, to show where AI was used and where it wasn't. But there are also third-party subpoenas that can go out to the different AI companies, and like OpenAI, for example, right now, it's under a preservation order. So all inputs and all outputs by court order have to be preserved, even if you say delete, because they're being sued for copyright infringement as a whole. A smart litigant could subpoena OpenAI and potentially get, that kind of discovery or other companies like it. So we'll see what happens, when those cases die down, then things may be back to standard preservation terms. But as of right now, everything you're feeding into an AI company that is under litigation, you should assume is being preserved in some law firm's bucket somewhere.
Someone says for property owner liability for infringements occurring on their property by tenants, are there actions the IP owner must take for there to be liability? In other words, giving notice or something like that?
The question is, there actions that the
owner of the IP should be taking.
owner of the IP?
Do they have to give notice to the landlord if they think that some tenant's violating their IP?
Yeah, they don't have to, but it's a good idea, or to CC them on the letter, things like that. In the case that Sarah talked about, there was actual notice, but there is also constructive notice. And courts have said constructive notice can be enough, and you can't be willfully blind. So if you see suspicious activity, or, in that Luxottica case, there were $200 sunglasses being sold as new for $10. Like, that's pretty suspicious in and of itself.
And there's a sort of a repeat of this question to sort of clean it up a little bit. They say most cases result in saying the use of photos isn't transformative. Are there any cases supporting transformative use of photographs where apparently that was allowed?
Yeah, I mean, I'm not aware of one where the photograph wasn't changed at all. And really, for something to be transformative, you have to have some sort of change. And courts have said just a change in the medium or just a change in the context isn't going to be enough.
Well, this has been fascinating. Certainly some things that most of us probably weren't aware of and wouldn't necessarily have expected could be issues. A little scary about how things that you don't really expect can create liability, especially, for example, the owner's liability for the tenant's infringement and issues like that. And we want to thank you so much for joining us and putting together this very interesting program on intellectual property and real estate coming together. And our thanks for putting together the program for us. And thank you to everybody who's attended.